Roses can be incredibly important in terms of the flower itself. So here we see some. They smell very nice. The yellow ones particularly, not so much the pink ones, but never mind. Yellow roses seem to smell the nicest. That's one lesson from this video. Roses also come up figuratively. So here is a set of rosary beads that we might think about, particularly when we're walking past a Catholic cathedral, for example. Or indeed the song Kiss from a Rose by Seal, the recording artist. They're all interesting ways of thinking about roses. But for us, and the purpose of this equity short, we want to think about rigours, which is a 1952 authority. Square brackets, Chancery at page 499. Now this is an incredibly important case when we consider the idea of the constitution of trusts, or at least the idea of formalities that attach to trusts and the passage of property. So in our continuum of cases, we've looked at Milroy and Lord when we were in Southport outside the Preston Bank. Next we have rigours, this case. And then following that we have Pennington and Wayne, which we have looked at the Windmill Farm. So rigours, this case, is incredibly important. Why? Well, because it represents a high watermark in a change in approach, an approach which is less severe than that which occurred in Milroy and Lord. So, what are the facts? Well, in essence, you had an individual who was trying to, in essence, avoid inheritance tax. And his name was Eric Hamilton Rose. In essence, he passed over 2 tranches, or purported to pass over 2 tranches of shares of 10,000 shares each to his wife in 2 separate tranches, as I say. And he attempted to do this in a way that would fall before he passed away, and hopefully transfer that property 7 years before he passed away, because if he successfully did that, he transferred that property to her, then of course when he dies it doesn't form part of his estate and isn't therefore susceptible to inheritance tax. So the battle for value, the question before the court, is to what extent Eric Rose's purported disposition was valid, or as compared with it not being valid and therefore the property falling still within his estate, meaning it's susceptible to inheritance tax. So the HMRC, the tax authorities, were the interested party here, versus, of course, the widow, who's asserting that the transfers were good of those share certificates, those shares, the value in those shares, of course, as well, and that therefore there is no inheritance tax to be paid. Well, in terms of formalities, Eric adhered to what the company required in terms of the passage of this property. So he filled in the requisite forms pursuant to the company's Articles of Association. I believe it was Article 9 that was the correct form of transfer, or the correct part of the Articles of Association that determined the correct form of transfer. So Eric completed the transfer forms, and those, coupled with the share certificates themselves, were passed over to the company secretary. And the company secretary duly entered the change of transfer in the books of the company. Ergo, it was argued that a proper transfer had been undertaken, at least in relation to the first 10,000 shares, and that the second 10,000 shares, that the company secretary had been given all that they could be given to undertake the transfer. So if one hadn't occurred in the interim, they, the company secretary, could be accounted someone who was put in a position to be able to execute that transfer. or that the settler, that Eric Rose himself, was in a position where he would be accounted a constructive trustee until that transfer had occurred, meaning that, of course, the wife is a beneficiary of that trust. In due course, her title, her beneficial title, is converted into a legal title when the shares have been properly registered at the company in her name. I say properly, I mean, say formally registered in the company's register. So eventually this case goes up before the Court of Appeal, and Lord Evershed, who was the Master of the Rolls at the time, hears the case, and he agrees with the first instance judge when he holds that an appropriate transfer had occurred, that the husband, Eric Rose, has done everything in his power, filled in the transfer certificate, passed the transfer certificate, caused the movement of those documents to the relevant individual who could correctly cause a transfer, meaning that the wife was successful in arguing that this disposition had been made, and HMRC were unsuccessful because, of course, the transfer had happened earlier than they had anticipated. It had occurred so that the 7-year period didn't bite, and therefore inheritance tax wasn't payable. So that's Re Rose, an important case in terms of its ingredients when we think about the passage of property over time and the mechanisms by which property can pass, particularly when it's chosen action, when it's a form of property which is intangible, namely shares, and the relevant formalities that are needed to transfer this intangible property. Namely, you need to look at the company's constitution, and you need to see what forms are required within that constitution to effect a valid transfer of that property. So, from this selection of beautiful roses, which I'll now sniff and have a look at, might make myself a cup of rose pouchon tea whilst I'm on the subject matter of roses, I bid you goodbye. So from here, goodbye.